For centuries, jurists have defined international law in terms of relation between sovereign states. After the Second World War, it became clear that the states did not always safeguard the rights of their citizens, and the issue of protecting individuals became more important in international law. International justice has been considered as an essential element of building respect for human rights, fighting against genocide, war crimes, and crimes against humanity. However, it has proved not being strong enough and has failed on its duties. When we talk about international or transnational justice, we need to focus on the main courts: the International Criminal Court, the International Court of Justice, and the several other courts to judge massive violation of human rights. First of all, the Statute of the ICC was approved in 1998 but did not enter into force until 2002 when the Treaty of Rome was applied. The role of the ICC is to judge the biggest perpetrator, meaning individuals, of major crimes when a crime has been committed in a country that has ratified the Rome Statute and is unable or unwilling to act. In other words, if you haven't signed the treaty, you cannot join the ICC, and currently only 124 countries have done so, undermining its capacity to judge major crimes. Some important countries both sign and ratify but withdraw, like the United States, only sign and not ratify, like Russia, and do not even sign, such as the case of China. The ICC has proved to fail in many aspects. The process is too slow, meaning that a few decisions have been taken in much time. Under the administration of the first prosecutor, only cases from African countries were investigated. It is also inefficient. The court has only successfully convicted 5 people on its entire history. It undermines national court system, which sometimes are more prepared to deal with a country's difficult past and prosecute the real perpetrator, and lack cooperation among the countries that have ratified the Rome Statute to make the process even slowly. The case of the Kenyan President Uhuru Kenyatta will be the best example. Kenyatta was accused of multiple crimes against humanity. However, he enjoyed of political asylum in other African countries that had ratified the Rome Statute but weren't willing to cooperate with the ICC, and therefore, the ICC blamed Kenyan authorities and media for obstructing the prosecution. The ICJ is the primary judicial branch of the United Nations, with the aim settling disputes and provide advisory opinions on legal questions. So it was set up in the optimistic days after the World War II, but has failed to develop into what its founders advised, a forum for solving international disputes. The court has no compulsory jurisdiction, so the ICJ itself has no power to start the prosecution against a state. It is composed by 15 judges under the power of the United Nations Security Council, showing who's behind the sentences. There are many cases in which decisions are not enforced because of the interest of the United Nations Security Council members that veto or simply disobey resolutions. So basically, it is the only court that assesses and rules on state-to-state disputes, meaning that it cannot prosecute individuals, and states do not accept the rules against them. Ad hoc tribunals are settled in post-conflict situations to prosecute perpetrators of domestic and international crimes with the aim to achieve peace and reconciliation. It must be highlighted that the Security Council provides the establishment for the ad hoc tribunal, so its creation is subject to the most undemocratic body of the United Nations system. As the courts are aimed in a single case, one, jurists are specialists in the country and the topic called, and sometimes they are biased and non-neutral, and two, it is undermined the capacity to create precedent for the establishment of a coherent and evolving international legal system, and therefore shows the inability of existing courts of developing their duties. We could hence conclude that the main weaknesses of international and transnational law are the inability to reach an enforcement of benefit, because there isn't a possibility to oblige states to follow the same legal frame, basically because of the world's diversity, the loss of sovereignty, with a dilemma on whether international organizations should be responsible for deciding on matters of concerning domestic law. Some countries do not want international courts to intervene and thus don't accept them. And last but not least, overlapping jurisdictions, regarding the mechanism to determine which court has the jurisdiction on which case.